Hey everybody, good to see you all in person. Okay, we've had our previous lessons all online, is that correct? Okay, good. Well, nice to meet you then. Yeah, who am I? My name's Ina. Okay, I'm not wearing a mask now because people find it hard to hear me clearly, all right? But I'm socially distanced, and I'll put it on at the break. Okay, no problem. Okay, so in case any of you are wondering. So tonight we shall, I think our break, I'll try to go until 8:15 and then have a 15-minute break. Okay, and then we'll go until I collapse. It's about 9:45 or something like that. Okay, so tonight we're focusing on the contract part of the course, and when we meet again on Saturday we'll be concentrating on the taught part of the course. There might be a little bit of overlap between the two. Okay, good. Also, if you have any questions at any time, feel free to put your hand up and ask. Okay, right. So, of course, these are revision classes. In other words, it gets you ready for the exam. Okay, so this is what we've got, examination technique. You don't have this PowerPoint, I don't think, so feel free to take a quick photo. Okay, I hope you're a bit quicker than I was. I was just sitting in Harcourt Garden, because I normally go there and have my coffee and sort of chill out before class. And I'm afraid I had a close encounter with a 4 to 6 foot snake. And that sort of shook me up a little bit. Just crawled out of the drain and just sort of... So I was going to take a photo of him to prove that I saw him. And then a big bird came down looking for it. Okay? It's like nature playing out in front. Anyway, enough about that. So thought I'd get that one off my chest. All right, so you never know. Life comes up with all these little surprises. Goodness. Okay. All right, so here you are, examination technique. Now, what I've got on the screen is largely relevant to Part B of your exam. Part B of your exam, there are going to be 2 questions. You do one. One will be a contract question, one will be a taught question, generally a problem question. So when I'm talking about examination technique, I'm talking about doing the problem question largely in Part B. But it carries 40 marks, so it's obviously quite important. So remember, your main aim as a law student is to be able to identify issues. What is an issue? A question for the court to decide. There is an argument for and an argument against. Okay? If you go to court and there are no issues, the judge will say, "Go away, wasting my time." Okay? So how do you identify issues? Well, the answer is use your definitions and explain your principles. Okay? So on our course, there are, in contract law, 6 must-know definitions. Now, let's be clear on this. It is memory work, yes. Okay? But if you're going to be a chemist, you've got to learn the periodic table. If you're going to be an architect, you've got to learn how to lay bricks, if you get my drift, okay? These definitions help you identify the issues. They are tools to help you identify an issue. Well, for example, what is an offer? An indication of a willingness to be bound on certain terms. So how do you know an offer when you see one? Well, is it an indication? Can be oral, can be in writing, okay? Could be by conduct even. Willing to be bound, but that depends on the wording, okay? And on certain terms. And remember, Carlyle is a very good example of the issue in Carlyle. Was that advertisement an offer or just an invitation to treat? And the court said it was an offer. It was an indication by written advertisement. Willing to be bound, they said, in order to show our sincerity, we're serious. We have deposited money in the bank, that's serious. Okay? On certain terms. Well, the defendant had a good argument. They said, well, not all the terms are certain. In particular, what's the period for catching the flu? Is it while you're actually using the smoke ball? Is it for a reasonable period afterwards? Or is it during the course of the pandemic? Okay? Good question. But the court said, well, we think it's certain enough. It's either while you're actually using the smoke ball or for a reasonable period after use. What is reasonable? We'll bring in expert medical evidence. Okay? Good. So there you are. Now we're in the COVID-19 pandemic. I don't suggest you use a smoke ball though. All right, so there you are. So these definitions, everybody, are your friends. They are tools to help you construct a good examination answer. They are tools to help you identify issues. So you've got to know the definition of offer, acceptance, consideration, exemption clause, misrepresentation, and frustration. Okay, good. And if you get a question in that area, say thank you very much, because quite often the second sentence you write in your answer will be a definition. For example, sorry, your name's Angela. Angela would like to know if she can sue Philip for misrepresentation. Okay, so let's say you advise Angela. Well, Angela would like to know if she can sue Philip for misrepresentation, full stop. So what's your next sentence? Misrepresentation is a false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. Thank you very much. Good. Then you have a look at what was said. Are all the elements of misrepresentation satisfied? Okay? Well, you know the two big issues with misrepresentation. Is it a statement of fact or opinion? And has the representee been induced? Okay? So these definitions, everybody, yes, must know. Is it memory work? Yes. Hello? Okay. Good. And of course, tools are no good unless you know how to use them. So practice makes perfect, okay? And the definitions I give you are the ones you should use. Your course manual's pretty good generally, but a little bit weak on the actual definitions, okay? So some students say, Mr. Greenberg, do I follow the course manual or do I follow my PowerPoints? Well, the answer is, I'll tell you, okay? Generally, the course manual's pretty good, but a little bit weak in some areas, okay? All right, so then having defined your terms and explained your principles, for example, the Gibson principle. Remember the Gibson principle? The court will analyse the existence of agreement, not contract, agreement in terms of offer and acceptance all the time, unless there are exceptional circumstances. Good. So that leads you on then to the definition of offer and definition of acceptance. Okay, good. So these are the tools to help you identify the issue. Now, if you're doing the question in part B of the exam and you can't identify any issue, what should you do? Don't do that question. There are issues there, you've just got to identify them. So what tools do you use to identify them? Definitions, okay? All right, good. And also the relevant principles, Gibson principle, acceptance principle, revocation of offer principle, part payment of a debt principle, okay, past consideration principle, they are all must know, okay? And yes, it's good to have exact wording because then you're clear on what you're writing down. And then having done that, apply to the question, arguing both sides, okay? Now, watch out for this. In an examination question, you're not given too much in the way of information, a few lines, whereas a judge in a real case has access to far greater information. And then the judge, a learned lawyer, will make a decision, and he may get it wrong, so it goes on appeal. So how can you, as a law student, in an examination with just a few lines of facts, come to the correct answer? So don't panic. Use your magic two-letter word. If it's an offer, if not, okay, good. By the way, don't go to the other extreme. Don't identify non-issues, okay? For example, in a question where the main issue is agreement, you're told there's been consideration, you're told who the parties are. Okay, so identify issues, but don't identify non-issues. Okay, good. All right, oh, this smart little gadget, I like this. Good. Practical tips for the exams. This is English law, the legislation. But highlight your cases. In the exam, just underline it because we're not doing it on computer just yet. In your assignment, you should have highlighted your cases and legislation just in bold print. Bold print's sufficient, you don't need to underline it. But in the exam, you're writing it out, so underline the case line. And by the way, everybody, use a straight line. Don't use a squiggly line, otherwise the examiner gets dizzy. Okay? And while you're underlining Gibson or whatever the case is, psychologically it's really good, because you know, oh, I'm going to get the marks. He won't miss this. Do you think the person marking your paper reads every word you write? I'm not going to answer that. But make sure he doesn't miss the fact you've identified that leading case or that leading piece of legislation. Now, of course, this is a closed book exam, so how much of the legislation are you expected to know? Good question. There's not much must-know legislation in our course, but there is some. And where it's must-know, you know what I mean by must-know, okay, likely to come up in the exam. All right, so definitely highlight your sources of law. Good practice. We've got the practical reason, but there's also the more noble reason to give due respect to the source of law. Okay. Use subheadings where appropriate. Okay. I tear my hair out where I see an examination answer which doesn't have any paragraphs. Okay. If I see an answer with no paragraphs, I sort of got to sit down and think of something nice and then try to understand what's going on. Right? So paragraphs are good, and keep your sentences relatively short and your paragraphs relatively short. The longer your paragraph, the longer your sentence, the more room for confusion. Okay? So again, common sense, don't go to extremes. You don't have to have every paragraph 2 lines long. Okay. My suggestion is have paragraphs, single space your answers, although if you want a double space, fine. But normally single space is better because it's easier to have your information in a more compact area than spreading it out, okay? Because it's easier to focus on one page than 2. But then perhaps leave a gap between your paragraphs. That's a good compromise, okay? And then adhere strictly to time. Oh, somebody, you were here on time. I normally want a late comment. Adhere strictly to time limits. Okay, so don't go over time when answering the questions. You're given the suggested times you should spend on each question. Don't go over time. You earn far more marks in the first few minutes of your answer than you do in the last few minutes, okay? And it's a shame to see some students doing the exam. It's clear they've run out of time, okay? So you've got to plan your time and stick to the time limits, okay? No need to write out your answer more than once, by the way. I notice I'm sitting here, and then rather neatly on the next one. Okay, I mean, good. By the way, the best subheadings are issues. What's an issue? Question for the court to decide. So quite often the best subparagraphs have a question mark. Okay, good. All right, any questions about that? Okay, good. Alright, so what I'm going to do is focus on the must-know parts by way of revision. I'm not going to go through in detail the whole course again, because we simply don't have time. But when I focus on a particular point, you know it's important, okay? Alright, so let's go through talking about formation of a contract. So what I intend to do in the first half tonight is cover all formation of a contract and also the contents of a contract. After the break, we'll concentrate on the vitiating elements, misrep, duress, undue influence, and unconscionability, and then we'll deal with termination of a contract plus remedies. Okay, good. So, everybody, don't worry about that, don't worry about that. First must-know principle, Gibson principle, must-know. Not sure whether it came up in your assignment, probably did. Is it likely to come up in the exam again? Maybe. All right, so don't forget it. The court will analyse the existence of agreements in terms of offer and acceptance unless there are exceptional circumstances. Is the level of court important? Yes, it is. Why? Because the Court of Appeal came to the opposite conclusion. So, do you need to remember case names? Yes. If you can't remember both names, one name will do. What happens if you can't remember any of the names? Well, in an absolutely desperate move, you could say, in a decided case. But please don't. Names are important, okay? So you do need to remember case names. And where the level of court is important, yes, House of Lords is important here, okay? Because remember, the Court of Appeal, Lord Denning said, you don't need to find offer and acceptance, it's too simple. Just look to see whether the parties agree on all the material terms, then you've got agreement. And it's not a bad argument, but the House of Lords said, no. We will analyse the existence of agreement in terms of offer and acceptance, but then sort of in deference to Denning, unless there are exceptional circumstances, okay? In your exam question, there will be no exceptional circumstances. Okay? And then, of course, must know the definition of offer and acceptance. Must know. Okay, what's on the screen is the appropriate wording. Can you cite a case for these definitions? Not really. So in the exam, you simply say offer may be defined as an indication of a willingness to be bound on certain terms. Acceptance may be defined as final and unqualified assent to the terms of the offer. Okay, good. Forms of offer, must know. Make sure you can distinguish between a unilateral offer and a bilateral offer. The difference is, in a unilateral offer, only one party makes a promise. The other party does not make a promise. Such as in Carlyle, Mrs. Carlyle didn't promise anything. Okay? And remember also with unilateral offers, you accept by performing the required act, whatever that act is. In Carlyle, it was smoking the smoke ball according to instructions. And then a bilateral offer, each party makes a promise. So of course, lateral means sided, uni is one-sided, bilateral is two-sided, you can have trilateral, quadrilateral, but we'll stop at bilateral. Okay, I would say, what happened there? Oh my goodness, okay. I'd say Hyde and Wrench, contrast, Stevenson, McLean, must-know cases. These are good examples of contrasting results, okay? So it's good to learn your cases in contrasting pairs. Hyde and Wrench, the reply from the plaintiff was a counter-offer. Why? Because it wasn't an acceptance, it was not a final and unqualified assent to the terms of the offer, because they qualified the price. Okay? Stevenson, McLean, CF means contrast. CF, the reply was simply getting clarification of the terms of the offer. Okay? So that was not a counter offer in Stevenson and McLean. And then I think on to the acceptance principle, must know. Torres must know case, acceptance must be actually communicated to the offeror unless, and the unless, the exceptions are important, it's a unilateral offer, because with the unilateral offer, Mrs. Carlyle, for example, didn't call up the smoke ball company and say, hello, my name's Mrs. Carlyle, I'm using your... No! She simply had to perform the required act. No communication required if it's a unilateral contract, okay? or the postal rule applies. I've got postal rule in inverted commas because it's not really a rule, but you do need to know the postal rule. If you get the postal rule in the exam, probably be part A of the exam. Could be either half a mark, half a question, or perhaps probably half a question. Explain what is meant by the postal rule of acceptance. But remember, put the postal rule in its place. Postal rule is an exception to the general principle. I'll come back. So what about the postal rule? Must know, must know. First of all, make sure you can state what the postal rule is. Acceptance is effective as soon as you put the letter in the control of the post office. It's an out-of-date rule, it's obsolete, it's very impractical, doesn't really exist in the real world, but examiners love it. Okay? Must know Adams and Linsell. Adams and Linsell is a must-know case on their postal rule. Remember, though, it only applies to acceptances, nothing else, and it only applies if it's reasonable to use the post. That's Henthorne and Fraser. And of course, how do you know whether it's reasonable to use the post? Depends on the nature of the offer and how it was communicated, and perhaps the wording of the offer. And why do we have the postal rule? What's the justification for it? Well, the court's saying you're treating the post office as agent of both parties. Also, there is a rationale of business certainty. You know you've got a contract, so you can get on and perform your obligations under the contract. Okay? But remember, it is an anomaly. It's an exception to the acceptance principle. The acceptance principle is acceptance must be actually communicated to the offeror, okay, entores. So, but as I say, it sort of seems to have a prominence way above what it deserves, but look out for it in exam questions. Remember, the other limitations of the postal rule doesn't apply to anything else, and doesn't apply where actual notice is required. That's Holwell Securities and Hughes, in which the wording of the offer indicated that the offeror wanted actual communication. I forget the exact wording in Holwell, but it says something. Anybody wishing to accept my offer, please let me know. Well, that was the court said that is requiring actual notice. Okay. So Holwell Securities and Hughes, I think, would be a must-know case. So what are the must-know cases on the postal rule? I would say Adams and Linsell, number 1. Henthorne and Fraser, number 2. Perhaps Grant. Grant is probably should know, must know. And Holwell Securities and Hughes. I think they would be my must-know cases on the postal rule. But criticise the postal rule, it's way out of date. I mean, we're in the electronic age, for heaven's sake. Right? But as I say, it can come up in the exam. All right, termination of offers. The important thing is the revocation or withdrawal of offer principle. An offer may be withdrawn at any time before acceptance, Payne and Cave, but must be actually communicated to the offeree. Byrne and Van Tienhoven, 2 must-know cases. Okay? And this is a must-know principle. Good. Slight gloss on that is, so Payne and Cave, Byrne and Van Tienhoven, must-know cases. Should know Rutledge and Grant, in that an offer can be revoked at any time before acceptance unless the offeree provides some consideration to keep the offer open. So that's Rutledge and Grant. Also, if there's no time mentioned in the offer will be open for a reasonable time. That depends on the nature of the subject matter. If you're selling bananas, particularly in this hot weather, right? I got some bananas 2 days ago. Then, have to eat quickly, compared to something more permanent. And then Dickinson and Dodds is a case sometimes comes up in exams, so it should know, not really must know though, in that the communication of the withdrawal of the offer can come through a third party, but the third party must be a reliable source such that a reasonable person would be persuaded of its accuracy. It's a very unsatisfactory decision in Dickinson and Dodds, but should know, I would think, not really must know. Because how do you know whether that third party is reliable? Okay, good. So we've covered the Gibson principle, acceptance principle, revocation of offer principle. We've covered the definition of offer, the definition of acceptance. Okay, good. And the postal rule. Anybody, any questions? Queries? Worries? Yes?
You mentioned that knowing the court is important, but some of them aren't really clear on.
Yes. The ones I tell you.
Oh, for example,
Sorry?
For example.
Yeah, if I don't mention the level of court, it's not important. Okay. But where I do mention the level of court and I say must know, must know. What level of court is Gibson? Are you sure? Yes? Definitely must know that one. Okay, good. I mean, and how you remember case names is up to you. Try and make up some silly joke or whatever about the case name that'll help you remember. I mean, my silly joke about Gibson, you know, he's a, what, is he still famous? A famous actor, Mel Gibson. Have you heard of Mel Gibson? You haven't heard of him? Oh my goodness, he'll be disappointed in that. Okay. Who's heard of Mel Gibson, the actor? Do you think he's handsome? Well, when he was younger. Okay. Oh. Okay, yeah, I know. I mean, he was the star of what? Lethal Weapon 1, 2, 3, 4? Braveheart. I mean, but then he rubbed the powers that be the wrong way in Hollywood, so he's been on the outer ever since. Anyway, there you are. Yeah, but case names are important. Okay, right. And level of court, where I mention it, must know. Okay, don't worry about that. We've got that one. No need to worry about that. The unilateral contract reward issues should know, I think, now. If you would, I'm not sure whether it came up in your assignment or not, but usually if it comes up, it will be one of the questions in the assignment. So I forget what your assignment question is, but it's interesting that with regard to unilateral contracts, the issues that arise, what is the notice advertising a lost dog or cat? Okay, is that an offer or an invitation to treat? Well, it depends. You know, was it an indication, willingness to be bound on certain terms? Okay? I mean, in my hikes from Moy Woad to Discovery Bay, there was a dog who was lost. His name was Clarence. There's another one, a cat that was lost. I'll get the name of the cat. And I said, oh, I took a photo of it. I said, is a reward? Oh, okay. There you are. Try to relate your contract law and tort law to your everyday experiences, okay? Because that brings the subject alive. Okay. And then with the reward issues, well, again, we don't need to worry about these, I don't think. Here you are, everybody. Good PowerPoint, this one. This is your template for answering any questions in the exam, where agreement is the issue, okay? Remember, generally, when the general issue, if you like, is there a contract between A and B? Has a contract been formed? You always start off with, well, for example, Angela would like to know if there's a contract between her and him, Philip. Okay, good, okay. Well, then Angela, what? The court will look for essential elements in the formation of a contract, agreement, consideration, intention to create legal relations, etc. Okay, and then you say, well, If the only element in issue is agreement, well then you do what's on the screen. Okay? State the Gibson principle first, then define, and of course tell the examiner you know it's House of Lords. And as I say, your course manual is a little bit weak on the Gibson principle. Okay? So some students said they missed agreement. Do I follow the course manual or follow your PowerPoints? The answer is follow my PowerPoints. Okay. Because generally your course manual is good. Okay. But not perfect. Okay. So is there an offer? Has it been communicated to the offeree? Normally that's not an issue. Is there acceptance? Has it been communicated to the offeror? That's often a big issue. Or has it been withdrawn before acceptance? Okay? So, so that's agreement. Anybody any questions about agreements? Must know the Gibson principle. Must know the definition of offer and acceptance. Must know the acceptance principle. Must know the revocation of offer principle. Must know the postal rule. Okay? All right, good. Right, on to consideration. The important thing about consideration, make sure you know the definition. And you can cite Curry and Miser as the authority for the definition of consideration as being reciprocal, benefits, and detriment. What do you mean by reciprocal? It means mutual. It literally means backwards and forwards. Reci means backwards. Procol means proceed forward. Okay? So if you're on social media and you're chatting with somebody on one of these dating sites, and you then go and meet that person over a coffee, and then they send you a message saying, "Hi John, it was nice meeting you, I really enjoyed it." Well, if John then replies, "Oh, the feeling's mutual, Angela." Oh, well. Reciprocal means mutual, okay? And of course, benefit means, profit if you like. Detriment means loss. So if I'm buying Angela's smartphone, how much? $10, okay, good. Okay, my detriment is I lose $10, the benefit is I get the phone, it's the reciprocal for you. Okay, your benefit is you get the money, your detriment is you lose your phone. Okay, so some students have a problem with those words, benefit and detriment. Okay, benefit's good, detriment isn't. All right. Curry and Miser has a much longer definition of consideration, but forget it. It's just 4 words: reciprocal, benefit, and detriment. That's it. Got it. Okay? And this idea of reciprocity, very important. Okay, so I must know the definition, and I would suggest Curry and Miser would be your authority. Okay, now some aspects not too difficult. Consideration must be sufficient, but need not be adequate. Can come up in part A of the exam, so watch out for that. Could be half a question. Chaplin Nestle, next time you have a chocolate and you're about to throw away the chocolate wrapper, think about it. Because that's what happened in Chaplin Nestle. If you collected, I think, 10 chocolate wrappers, you get a free chocolate. But on their own, pretty well worth nothing, right? But the court said, doesn't matter, as long as it's of some very, very small value, that's okay, but it need not be adequate or equal. So you can buy a very expensive car for $1 Hong Kong dollar. No problem. Obviously not adequate, they're not equal, but would be sufficient. Okay. And then I've got these ones on Chappell and Nestle. What may be difficult with well, actually, hang on. Where is it? Oh, sorry, I'm just flipping through here. Past consideration. Let's deal with past consideration. Remember, past consideration, you've got to be able to identify the situations where there is past consideration. It's where somebody has already performed obligations, then the other party promises to pay them for it. So that's past consideration. And the general principle is past consideration is not good consideration, full stop. And your authority is either Roscola and Thomas or Re McArdle, take your pick. Either one will do, okay? But if the act was done at the request of the promissor and the parties understood it would be paid for, that is not past consideration, that is good consideration. Remember Lampley and Braithwaite. Braithwaite was sentenced to death, and remember this is a 17th century case where the king had absolute power. And so Braithwaite went to Lampley and said, can you please go to the king and get me a pardon because I'm too young to die. Lampley somehow or other got the pardon. And then Braithwaite said, did you get it? Yes, I did. Oh my goodness! Wow! You saved my life. I'll give you £100, which is a lot of money in the 17th century. And then Braithwaite refused to pay. He said, no, past consideration. The courts disagreed, said no. Was the act done at the request of Braithwaite? Yes. Did the parties understood it would be paid for? Well, Lampley said, you bet your life, because I was taking a big risk here, because the king has absolute power, and if I'm asking this silly question and he's had a bad day, I could have had my head chopped off. Was not doing this for nothing. Okay. And the court agreed. Okay. And then Powon and Lau Yu Long is a useful case to remember. It is Privy Council, worth remembering. And the Privy Council, of course, was the Court of Final Appeal before the handover. Okay, so watch out for that. Which is interesting, I just walked past the Court of Final Appeal today. I said, my goodness, before the handover, you had to pack your bags and fly to London. Wasn't that stupid? Anyway, there you are. Okay. So Powon is a useful case to remember because it's the authority on that second bullet point. Okay, so worth remembering. Powon's also leading authority on economic duress. Okay, so worthwhile remembering. It's good to have a case which is authority for more than one issue. So Powon is a good case to remember. Okay. Let's not worry about that one. Now we come on to the must-know cases here. Stilk and Myrick, contrast Hartley and Ponsonby, and in particular, Williams and Roffey. Williams and Roffey is a very important case for you because past exam questions in Part B have been based on the facts of Williams and Roffey. Okay, so I'm going to go through Williams and Roffey in a bit of detail again. But remember, the general issue is performing a existing contractual duty. Is that good consideration for extra payment? The general principle is no. Why not? Because the worker is simply performing his existing duty. He's not suffering any extra detriment. And what is consideration? Reciprocal benefit and detriment. Okay? And that's with the finding in Stilk and Myrick, in which the House of Lords, remember, a ship sailed from Port A to Port B, but on the way some of the sailors got sick because in the 19th century, if you're a sailor on board a ship, good luck. Because a lot of them either died at sea from disease like scurvy or fell overboard or whatever. Okay? So on the voyage, some of the sailors did get seriously ill, so the captain promised the remaining healthy sailors, I'll pay you extra money to complete the voyage. The sailors then say, okay, where's our extra money, Captain? The captain said, no consideration. You're performing your existing duty. You've suffered no extra detriment. And the House of Lords agreed. By contrast, CF, Hartley and Ponsonby, ship sails from Port A to Port B. And you've seen those pirate movies with Johnny Depp, Pirates of the Caribbean. What do sailors get up to when they're in port? Well, they drink a lot of port. So this is what happened. The sailors got drunk or got ill, and so the captain promised the remaining healthy sailors who were still sober, I'll pay you extra money to complete the return voyage. So the sailors completed the return voyage. They said, okay, where's our money, Captain? He said, oh, no. But the court now agreed with the sailors. They said, well, there are actually two contracts here. A contract to sail from Port A to Port B, and then a separate contract to sail back from Port B to Port A. And so the sailors were able to claim the extra payment in Hartley and Ponsonby. Okay? All right. So, two House of Lords cases worth remembering. House of Lords. On sort of similar facts, but with opposite conclusions. Good to remember cases in contrasting pairs. Okay, good. But then we come to Williams and Roffey. Now, Williams and Roffey, everybody, is a very difficult case, and your course manual does summarize it pretty well. It's hard to follow, the law's a mess, etc., etc. But know the facts of Williams and Roffey, and you can nail any question in the exam on it. What were the facts? There's a contract between A and B, so a main contractor and a subcontractor. For the subcontractor A to build a certain number of units at a certain price by a certain time. But then the main contractor got worried because the work was behind schedule, so he approached the subcontractor and said, listen, you're behind, I'll pay you extra money to speed up and finish on time. Why was the main contractor worried? Because he was under a penalty clause if the work wasn't done on time. Okay? So the work was done, so the subcontractor said, okay, where's our extra money? Well, the main contractor argued, still can worry. Oh, you're just performing your existing duty. No consideration. You have suffered no extra detriment. But the court disagreed. They said there is good consideration here, and the main reason is point number 4. But point number 4 is very controversial, because point number 4 says, well, there's extra benefit to the main contractor, and that's good enough. But everybody's been scratching their head ever since, not because they got dandruff, but how does this work? I mean, what is this extra benefit? Well, you could argue in Williams and Roffey it was avoiding the penalty clause, but wouldn't the main contractor argue, well, aren't I entitled anyway to avoid this by having the work done on time? So nobody has been able to satisfactorily explain what this benefit is. Is it factual benefit? Is it practical benefit? What is it? Good question. One way of looking at this is in the UBC construction case, a Hong Kong case. The judge in that case, Mr. Justice Kaplan, who was the one who actually got me interested in law, would you believe? That's another story. Anyway, he said, well, there's a practical benefit to getting the job done. And we need projects to be completed. That's the argument. Okay, there's a practical benefit, pragmatic approach, if you like. But everybody said, well, hang on, where is the extra consideration? The answer, everybody, quite frankly, there is no consideration. But this is a decision of the Court of Appeal, must know Court of Appeal. Okay? And of course, you have to, dig around. Where is this extra benefit to the promisor? Well, as I say, the only sort of feasible answer is, well, you get the job done. But you can criticize this. Isn't this encouraging inefficient work? Okay? Because let's say you are competing with other contractors for a big project. What might you do to get the contract? Bid a very low price. You get the contract. And then what do you do? Put up your feet. Take your shoes off. Do nothing. He's going to come to me and promise me extra money for doing the same work. So everybody see the argument here? It seems to encourage inefficient work. And indeed, that's one of the complaints about these projects at the airport, in that there have been problems with this, and Williams and Roffey's come up. Okay, so there you are. And then we come to point number 5. Point number 5, economic duress. Everybody must know economic duress. It could come up as part of Williams and Roffey. It could come up as a separate half question in part A of your exam. In other words, the promise must not have been extracted as a result of economic duress. What is economic duress? A threat to do something illegal, such as being breach of contract. The other party has no practical alternative but to agree, and the innocent party has protested. Okay? In Williams and Roffey, economic duress was not pleaded, but some academics argue there's sort of implied economic duress, by sort of, not working to schedule. You're sort of putting pressure on the main contractor, are you not? He probably doesn't have any alternative but to keep using you. Okay, so subtle argument there. So what are the restrictions on Williams and Roffey? Well, point number 4, which is very controversial. Where is this benefit? Point number 5, there must be no pressure put on the promisor. And then point number 1. Point number 1 says Williams and Roffey will only apply to contracts for sale of goods or provision of services. It will not apply to contracts for payment of a debt. Why not? And the answer is Folkes and Beer. Folkes and Beer, House of Lords, must remember House of Lords. Why? Because the House of Lords is higher than the Court of Appeal, Williams and Roffey. Williams and Roffey's only Court of Appeal decision. Folkes and Beer says part payment of a debt is not good consideration for the whole debt. Must know. To come up part A of the exam. Explain what is meant by the part payment of a debt principle. So you tell the examiner part payment of a debt is not good consideration for the whole debt. Forget about Pinnell's case, it's House of Lords, Folkes and Beer. Remember, in Folkes and Beer, Mr. Folkes owed Mrs. Beer a certain sum of money. They agreed he could repay the principal pay half of it first and the rest in instalments. He paid off the principal, and then he went to Mrs. Beer and says, please now declare me debt-free. She said, no, you still owe me the interest. And the court agreed. Part payment of a debt is not good consideration for the whole debt. So the important thing about this is it's a debt case. So this is why Williams and Roffey cannot apply to contracts for payment of a debt, because Folkes and Beer is House of Lords, Williams and Roffey's only Court of Appeal. So we have a very artificial distinction between contracts for sale of goods and provision of services on one hand, and contracts for payment of a debt on the other. The law is a mess. But as long as you appreciate that, you'll get really good marks. Okay? So you've got this case on the screen. Reselect Move is a Court of Appeal decision which says what I've just said, in that Williams and Roffey will not apply, NA, not applicable, to part payment of a debt case. All right? So a little bit tricky there, but know the part payment of a debt principle. Know it's Folkes and Beer, which is House of Lords. And then with regard to Williams and Roffey, know the facts of Williams and Roffey, okay? And you could get this in the exam, could be the full 40-mark question in part B. You might find the facts tweaked slightly. For example, in the exam question. It could be the the subcontractor approaches the main contractor asking for extra money. Well, if that's the case, that looks a bit more like economic duress. Okay, so know the facts as they stand on Williams and Roffey, but the facts could be slightly changed in an exam question. But know the important points about Williams and Roffey. It only applies to contracts for sale of goods, provision of services, because of Folkes and Beer. There must be some extra benefit to the promisor, whatever that might be, and that's very unclear. And there must be no economic duress exerted on the promisor. Okay, good. So let's go back to the part payment of a debt principle, because you could get a separate question on this. Could be a 20-mark question, part A of the exam. There are exceptions to the part payment of a debt principle. Make sure you know the exceptions. Payment in a different form or payment earlier, obviously the debtor is suffering extra detriment. Okay. Also, if there's payment by a third party, that's extra benefit to the creditor because the third party doesn't owe him anything. That's IRC and Fry. Okay. And there's been recent case law in England, this Rock Advertising case 2017, in which the courts seem to be bending over backwards to find there is some consideration for part payment of a debt. And the facts of Rock Advertising are a little bit not easy to follow, but the court seemed to say there was some benefit to a landlord in that property was occupied by somebody, and that was a benefit to the landlord, even though the somebody couldn't pay the rent. So part payment of a debt is not good consideration for the whole debt. Folkes and Beer, House of Lords, but there are exceptions to it, and might like to know the part payment of a debt principle is under a bit of an assault at the moment, as illustrated by the Rock Advertising case, in which the courts seem to be finding exceptions to justify part payment of a debt. Okay, right. Promissory stop or forget. Won't get any question on promissory stop. So that's consideration, everybody. Any questions? What must you know? The definition of consideration: reciprocal, benefits, and detriment. Curry and Miser. Must know Williams and Roffey. Remember the arguments in Williams and Roffey. The main contractor argued, subcontractor, you have provided no consideration for the extra payment because you're performing your existing duty. But what was the argument of the subcontractor? We have provided good consideration. And that's the argument that won out in Williams and Roffey. Okay? But the court said, well, there was good consideration because there's extra benefit to the promisor and there was no economic duress. Okay? But very, very controversial case, Williams and Roffey. Okay? Don't forget the part payment of a debt principle. Must know, must know. Folkes and Beer, must know, House of Lords. But be aware of the exceptions. Payment in a different form, or payment earlier, or payment by a third party. That will be consideration. Okay, intention to create legal relations. We can cover this pretty quickly. Must know the presumptions. Remember, the law often acts by way of rebuttable presumption. So they'll presume something is the case unless there's evidence to prove otherwise. So what are the presumptions? Quite straightforward. In a domestic situation, there is a presumption of no intention to create legal relations. It's the opposite in commercial arrangements. There is a presumption of intention to create legal relations. Okay? That's must know. should know. Often the distinction's not clear, okay, particularly prenuptial agreements, okay, which just sound very unromantic, aren't they? But, you know, my goodness, getting married, what a big step. Of course, are they, of course. Okay, now let's have a look at rebutting the presumptions. Well, first of all, what's a must-know case on the domestic presumption? Balfour and Balfour must know. Don't worry about the level of court. It's Court of Appeal, but most of you know the case name. Remember, it was a husband who was posted overseas to Sri Lanka. His wife couldn't join him because she was ill. A bit like Megan not being able to attend Prince Philip's. No, she's not. So he promised to pay her a monthly allowance while he was away in Sri Lanka. Now, when you're away from your loved one, two possibilities. Is it out of sight, out of mind? Or is it absence makes the heart grow fonder? Well, he's in Asia, isn't he? I mean, Asian ladies are just gorgeous. Right, Angela? Yes. No, not. Well, he met some lady, and of course, guys, you know, I sound a bit sexy here, but anyway, it's difficult maintaining one lady. It's impossible to maintain two, so he had to give up one. So he stopped the payments to his wife. She sued him for breach of contract. He said, no. This is a domestic situation. There's a presumption of no intention to create legal relations, and the court agreed. So the facts are sort of interesting. So Balfour and Balfour, good illustration of the presumption in a domestic situation. But remember, the presumption can be rebutted. Simpkins and Pays, stroke Wu and Chu must know. That has come up in past exam papers. Remember, in a domestic situation, you've got to look how close is the relationship. And in Simpkins and Pays, it wasn't that close. It was a boarder, the owner of the property, and a granddaughter. So it's easier to rebut the presumption when the relationship's not so close. So remember the lottery win. So the person who actually had the winning ticket said, it's all mine. They was, hey, hang on, what about our share? We agree 1/3 each, and the court agreed. There was evidence to rebut the presumption. I'm not sure what the evidence was. Similarly in Wu and Chu, when somebody won the Mark 6, I think it was. So if your surname's Wu or Chu, there's a case you should remember. Parker and Clark's my favourite one because Parker's my mother's maiden name. But anyway, strictly irrelevant. Relatives sharing a house, but the court found that the presumption was rebutted because the plaintiff gave up their own accommodation to move in. So that was evidence to rebut the presumption. Okay? Merritt and Merritt is a divorce case, so they were no longer in amity, they were no longer in love, so that was rebutted in Merritt. Jones and Patterbatten is a difficult case in that it looks very much like the daughter, provided, there was evidence to rebut the presumption, because the mother, M, persuaded the daughter to give up her US job, come back to England and study for the bar. E is England, okay? And in return, the mother promised to give her a weekly allowance, but then the mother stopped paying, so the daughter sues the mother. The mother argued, this is a domestic relationship, no intention to create legal relations. But the daughter said, hang on, strong evidence here. I gave up my job in America, moved back to England to study law. Sounds like pretty strong evidence to rebut the presumption. But the court said there was no enforceable contract, not because of that. In Jones and Patterbatten, they said we couldn't figure out exactly what the terms of this contract were. So Jones and Paterbatten failed more for lack of certainty than for an intention to create legal relations. So it's a slightly difficult case, Jones and Paterbatten. I think Simpkins and Pays, Wu and Chu, Must Know. I think Parker and Clark is a good case as well. Giving up your existing accommodation is strong evidence to rebut the presumption. And that's what I say in this one. So rebutting the presumption in domestic contracts, it depends on the circumstances, the context in which the agreement was made, that's merit and merit, obviously no longer in love. Reliance on the agreement, Parker's a strong case, but then Jones and Paterbatten, the court said there's no contract, mainly because there was no certainty of terms. Okay. All right. And then with commercial agreements, all you need to, the only must-know case is Edwards and Skyways. The rest forget. It's only Edwards and Skyways, and it's quite straightforward. In commercial arrangements, there is a presumption of an intention to create legal relations. So the airline pilot made redundant, which sort of does remind us of the very sorry state of the airline industry at the moment. So like 90% of pilots are not working at the moment. Actually, I went out to the airport because I've got my BioNTech appointment, and I said, I had to go to the Ground Transportation Centre. Where on earth is the Ground Transportation Centre at Cheklak-Kop? I had no idea. Well, it's actually quite near the where you take the lifts up to the anyway. I found it, but it was so quiet. It's like a ghost town. Anyway, so Edwards and Skyways, must-know case, must-know. The rest forget. All right, everybody. So that's intention to create legal relations. Anybody any questions? Queries? Good little topic. If you get a question on intention to create legal relations, it'll be part A of the exam. Could be the full 20 marks. Not difficult. Okay? And make sure you can state the rebuttable presumptions. Cite Balfour and Balfour for the domestic situation, and then cite Simpkins and Pays, stroke Wu and Chu, perhaps Parker and Clark, and then with commercial arrangements, Edwards and Skyways, you've pretty well got it covered. Okay? Good. All right, let's move on then to terms. As I say, those people that came late, we'll have our break at 8:15, and we'll go for 15 minutes for the break, okay? So if you're wondering, when's he going to stop? Well, now you know. Okay, with regard to terms, forget the first bullet point. The second bullet point, should know, perhaps must know. There have been questions in past exam questions on implied terms, so we'll go through that. Classification of terms, must know, comes up as a separate topic in part A of the exam, could also be relevant to part B. And then exemption clauses, absolutely must know exemption clauses, must know the definition, okay? And we'll go through the law on exemption clauses as well, okay? All right, so let's skip the first one, just go straight to implied terms. I'm not sure whether this is, if I got it. I don't, separate one. Okay, implied terms, not difficult. Remember, the courts are reluctant to apply a term into a contract. Why? Because the courts don't want to get into the bargaining process between the parties. In contract law, it's the parties who should decide what's in the contract. The courts don't want to get involved, because they haven't got time. But they will imply terms by custom, on the facts of a particular case, or by the common law. What do you mean by common law? Referring to specific types of contracts, such as employment contracts and perhaps leases. And also, terms can be implied by statute. And the only must-know statutory provision, everybody, I suggest, is Section 16 of the Sale of Goods Ordinance. All right, it's legislation, and this is a closed book exam. but as long as you can paraphrase section 16 of SOGO, if you get a question in the exam on implied terms, work in section 16 of SOGO, and you'll get good marks, okay? So let's go through this. First of all, terms implied by custom. I would suggest Hutton and Warren is a straightforward one. English case, the tenant could claim the cost of seeds and labour when the lease was terminated. Because, I mean, it's not like Hong Kong, in England, that you can grow your own fruit and flowers or whatever. Okay, so it was a custom in England that the tenant could claim the costs of any money he spent on seeds or labour. Okay. Smith is an Australian case. In Australia, had a plague of rabbits. Australia allowed rabbits to come in to kill off some other pest. The rabbits they didn't appreciate are very good breeders, and so the rabbits themselves became a plague, and rewards were offered for producing a number of rabbit skins. So you go out and kill them, all the rabbits, okay? And if you could produce certain number of rabbit skins, you get paid a certain sum of money. But it was an implied term that 1,000 meant actually 1,200 rabbit skins. Right, so there you go. I hope you don't like rabbits, but anyway. Right. Hutton and Warren is the only must-know case here. It's a dead easy one, okay? But it must be a well-established custom, and it must not contradict any express term in the contract. Also, terms can be implied by the courts under the business efficacy test, stroke the officious bystander test. There is really no difference between the two. And the Moorcock is a must-know case. It says, is the term necessary to make the contract work? In other words, give it business efficacy. Well, that depends on the facts. In the Moorcock, it was a ship moored at a pier, and then what happened when the tide went out, the ship sank and the bottom got damaged. There's nothing in the contract covering that, so the court implied a term that there would be no damage to the ship to make it work. Okay? But again, the courts are very reluctant to imply terms here. So the business efficacy test is all you must know. Moorcock is all you must know. Is a term required to make the contract work? That's basically it. Let's not worry about that. Let's not worry about that. Terms implied by the courts. This deals with specific contracts, landlord and tenant. The court implied a term that the landlord has an obligation to take reasonable care to maintain the common parts of the building. This was not expressly set out in the contract, so the courts implied it, okay? But then a case you can all relate to, everybody, Malik and the Bank of Credit and Commerce International, which was quite a high-profile bank in Hong Kong in the early 80s, but it went bust. Why did it go bust? Because it was funding terrorism. Okay? Malik was an employee, he lost his job, and he sued the company for breach of his employment contract. Well, the bank said, look at your employment, there's nothing there. What clause are we in breach of? And the court implied a term into the employment contract that the employer must conduct a dishonest or corrupt business. So there you are, everybody. I hope your employer is honest, because if they're dishonest and corrupt and they go bust, you can sue them for breach of contract. Interesting. I like Malik, good one. Thank you. Andiani and Chan is the Indonesian golfer case in which I think all of the terms, the express terms, were made void because of illegality, lots of undue influence. But there was a contract between the employer and employee, so the court had to imply all of the terms into the employment contract, in particular what was the salary, what was the minimum wage, and And so the worker had worked for 9 months, I think, so they got 9 months' salary. That was their remedy, quantum of damages. Okay. So that's terms implied by the courts. Terms implied by statute, I would say only section 16 of SOGO. I would suggest must know. Section 16 says there's an implied term in every contract for sale of goods, that the goods are of merchantable quality and fit for purpose. There is one rider to that. If the buyer has a chance to inspect the goods and any defect is easily discoverable, then there'll be no breach. Okay? So section 16, not too bad. I mean, what do you mean by merchantable quality? Good question. The English legislation uses the word satisfactory quality, which is probably a better word. So everybody, section 16 SOGO implies a term into any contract for the sale of goods, that the goods you buy are of merchantable quality and fit for purpose. Good. So if you can remember that and work it into the exam answer, you'll do quite well. And of course it applies to everybody, doesn't it? I mean, when you buy any electrical goods, for example, you don't want it catching fire or injuring you. And by the way, this implied term is a what type of term? Condition. Which means if there's breach, you, the consumer, can terminate the contract and claim damages. Okay? So we're getting on to that now. All right. Oh, by the way, you could, if you get a question on implied terms, you could, have I got it here? No, I haven't. Oh, it doesn't matter. Okay. You could include supply of services implied terms ordinance in sort of general terms, which covers contracts for provision of services, not sale of goods. But classification of terms must know. Obviously, the distinction between a warranty and conditions not too bad. Warranty is the less important term, breach of which gives the innocent party the right to damages only. The contract carries on. Conditions, of course, breach of a condition entitles the other party to terminate the contract and claim damages. Well, that would be dead easy if that was it. But unfortunately, we've got this intermediate or innominate term in which Lord Diplock says there are some terms which cannot be categorised as conditions or warranties. So we will look at the effect of the breach. And the test is, and very important, is the innocent party deprived of substantially the whole benefit of the contract? Substantially the whole benefit of the contract. Because if they are, then that's breach of a condition. If not, it'll be breach of a warranty. Okay. And must know that test, by the way. Is the innocent party deprived of substantially the whole benefit of the contract? I emphasise the word substantially, and I'm looking at the course manual, and I'm not sure whether the page reference is the same as yours, but in Wallace and Pratt, it's under the heading 2.3, so it's chapter 2.3, under the heading classification of terms. If you've got your course manual, get out your pens and highlight the word substance, because Wallace and Pratt says, but from a very early period of our law it has been recognised that obligations are not all of equal importance. There are some which go directly to the substance of the contract, or in other words, are so essential to its very nature that their non-performance may fairly to be considered by the other party as a substantial failure to perform the contract at all. On the other hand, there are other obligations which, though they must be performed, are not so vital that a failure to perform them goes to the substance of the contract. The word substance is mentioned 3 times in that short extract from Wallace and Pratt. And so this is why the test for an innominate term is the other party deprived of substantially the whole benefit? Because if they are, we'll treat it as breach of a condition, if not, breach of a warranty. Okay? All right. Everybody, I think that's probably a good time to have our 15-minute break. Anybody, any quick questions? Okay, good. So we'll have a 15-minute break, and after that we'll finish off the terms of a contract, and then we're going to get on to the vitiating elements.